focusing on corporate and IT governance, and within that context, data privacy. My background prior to that was as an academic with 3 of South Africa's leading business schools over a 12 to 14-year period. And before that, I spent nearly 20 years in the IT industry. So I'm a veteran of sorts, but I bring not a legal perspective, but a more operational information security and governance perspective to the privacy discussion.
Fantastic. Thank you, Peter. And you and I have had the privilege of working together on several different projects over the years in some interesting places in Africa. So lots of war stories to tell from those as well. But that's a topic for another day. So anyway, folks, I'm going to keep an eye on the chat. But just to give you a little bit of a sense for the structure and format for today, we're going to Peter and I are going to have a brief chat around data protection and privacy, legislation, and how that impacts boards and organizations. And we're going to do that for about half an hour or so, and then leave some time open for questions that you might have for Peter. I will keep an eye on the chat box as well as we go along. So if you do have any questions at any stage, then please feel free to post those in the chat, and we'll do our best to answer those as well. So, Peter, I think perhaps maybe just as a departure point, just give us a bit of a sense for what data protection and privacy is in a sort of broad definition.
Well, it might surprise you if I tell you that not the definition of what is data protection, but the impact it's having on boards and directors. It's one of the hottest topics, alongside green environmentalism, how are we going to survive COVID? Some of the key questions now are, how are we going to meet the expectations of stakeholders? And this area of data protection is probably the hot topic today that quality was in the past. Or, there are things that come and go in waves. Only data protection is not going to be a wave, it goes. It's here to stay. And I think that if we look around the world at the different, we've heard, I'm sure, the expression, data is the new oil. Well, if you have trouble in your car engine or gearbox or whatever, and you need to take the car in for service, and you're having trouble with the oil, today you're going to be having trouble with the data in the business. The old days of saying my business process is creaking, and I've got trouble here and there. Today, a lot of that discussion is around data. Who stole my data? Who moved my data, like my cheese? And why is this? It's because there's a global awareness that so many of us are feeling disenfranchised. Individuals, whether they're employees or customers, now want to have their voice. And this is a version of stakeholder activism, which is rearing not an ugly head, but an opportunity that if you get it right, maybe you're going to improve the way your customers see you, the way your employees see you, and maybe even the people who want to do business with you. Some of your vendors are going to be keen to be associated with an organization that understands the importance of data and the way it needs to be on the boardroom agenda.
Data is a pretty broad kind of definition. So when you talk data, what does that encapsulate?
I think it's very important that the move we've seen in terms of legislating the use of data is almost all around personal information. Information about you and me, about our organization, maybe, that leads to who we are, such as I have a name, and when I start doing a search, I quickly find that my name's mentioned on a corporate website, and you can figure out who somebody is by pulling together all the threads. So that's one aspect of data, which is personal information. But there's a very important other aspect, and that is the non-personal data. So this is business information, which can come in many forms, including that which is protected under intellectual property rights, copyright, trademarks, and so on. And that sometimes we lose track of the fact that data is a valuable asset to boards and to directors in decision-making, and that a subset of all data, that is personal data or personal information, is where we're seeing the legislation coming down hard in terms of what restrictions are being put in place. So boards need to understand, I'm sure many directors already understand, that improved decision making is about leveraging important information about the business, looking at trends and variances and doing long-term strategies and forecasts. That's old news because we've been doing that for, well, a number of generations in business, understanding the importance of data as a whole. Now we are moving, and we have been for the last, depending on which country you're in, which part of the world you're in, for the last 10, 20, or in some cases 30 years, recognizing that legislation is playing an increasingly important role in how we evaluate what we need to do about personal data or personal information.
And obviously, and I would imagine it's been ongoing for a long period of time, but it's certainly more prevalent in terms of people being hauled up in front of congressional hearings, the likes of Mark Zuckerberg and all of these kinds of things. So we're definitely seeing a proliferation of a focus on data protection and those kinds of aspects, certainly at a high profile level. And I would imagine if it's happening at a high profile level, it must be occurring at lower levels as well.
Yeah, look, I'm guessing that many, if not all, but many of the people who are on this call today are based in South Africa, where I am, and we can trace our roots back all the way to the Constitution. 1996, South African Constitution included in the Bill of Rights is a statement that we're entitled to privacy. None of this is new to people who live in the other parts of the world that have a constitution that stretches back even further. I believe the US is one of the countries that claims to have one of the oldest democratic constitutions in the world, going back to the 1700s. And the right to privacy there is something that has been recognized, therefore, for a good couple of hundred years. If you go to 1948, when the United Nations Declaration of Human Rights, Universal Declaration of Human Rights of the UN, was established, privacy was one of the building blocks. There's no surprise that the South African Constitution is aligning to best practice internationally, to the UN and the Universal Declaration of Human Rights. But we haven't had a mechanism in South Africa like they've had in other parts of the world, in particular where I come from in the UK. Go back to 1984. Perhaps the folks on the call this morning would just like to scratch their head a little. Hopefully nothing comes up. But scratch your head and say, where was I in 1984? What was I doing in 1984? Because in 84 was when the UK government passed their first Data Protection Act. And later, when the European Union started to get teeth, the first European Union directive was issued in 1995. Think back those years. Only now in South Africa and other countries around the world are we catching up to some of the international leaders. And of course, I've skipped in between. We've seen the European Union take a second bite, if you like, and implement the General Data Protection Regulation, which is now European-wide enforced, as opposed to the old approach, which was each country makes up its own rules under a broad directive. Lots have been happening, and South Africa now needs to catch up. Why? Apart from anything else, because we're going to be a less favored trading nation once we get our act together and look like a place that people can feel secure in doing business with.
Okay, so I've had a look at the attendee list today, and in fact, we've got South Africa, Ghana, Kenya, Nigeria. So we've got quite a broad kind of reach in terms of people attending. So you're obviously talking South Africa, you're talking GDPR, which is your EU. South Africa, it's POPIA, or the POPIA Act. But as you mentioned, the legislative context is relevant in countries like Kenya, Ghana, Nigeria as well, in different ways.
Absolutely. Yep, I'm delighted to say that this very morning I've received from a client who's based, their business is based in Europe, but operates in multiple countries. And I've been advising them both here and in Nigeria. So anybody who's on the call from Nigeria will know that the data protection regulation, which has been issued there, is now in full force. In fact, the Nigerian authorities have moved much faster from the draft legislation through to full impact. If you look at some of the other countries you mentioned, places like Ghana and Kenya and so on are increasingly dependent on their international credibility. So we've seen multiple countries around not only the SADC region, the 15, 16 countries, but elsewhere in the AU have taken steps, in fact, more quickly than South Africa. Outside of South Africa, I've done multiple projects for clients based in Mauritius. And Mauritius has already applied for an adequacy decision from the European Union. This means, please, EU, see the whole country as a trusted nation in terms of trading relations. That's going to give the Mauritians, as it has other places such as Japan, New Zealand, and elsewhere in the world that has that adequacy decision, a preferred basis on which they can do business with the counterparts in Europe, whether they are dealing with suppliers or customers.
So if we just perhaps focus and just use South Africa as an example right now, where is South Africa in this process of legislation and passing legislation? Because POPIA is not new, but I'm a little uncertain as to whether it's enforceable. Where are we?
I've heard the POPIA Act described perhaps rather unfairly as a broken down car with flattening tires, running out of gas, and we are coming to the starting line to try and take part in the international race to credibility. Our legislation in South Africa is in force and has been since the 1st of July last year. The POPIA Act is in force. One or two minor exemptions at the moment in terms of the requirements under the Act. For example, the regulator has not taken over responsibility from our Human Rights Commission, who's been running with a related piece of legislation, Promotion of Access to Information Act, since 2002, when that came into force. So we have the legislation. We do not have teeth from the regulator. We had a 12-month transition period, which many people mistakenly said, oh, well, the POPIA Act's not coming in until July of 2021. No, it's when the regulator has powers is July 2021. The Act has actually been in force since 1st of July last year. The challenge is that the fundamentals underlying the POPIA Act date all the way back to 1995 and the original European directive, which then took 10 years to meander through the parliamentary process. And after it was put on the statute book in 2013, only now, some 7 years later, are we seeing the POPIA Act actually having meaning in the local environment. And that's really damaging for our international trade. Whatever the credibility is in the local environment, the regulator herself, Advocate Panti Tlakula, has highlighted the fact that the slower we are to implement the full implications of the POPIA Act, the less South Africa is able to compete on the international stage.
So you've mentioned credibility a few times in the discussion so far this morning, and obviously you're talking about credibility at a national or at a nation level, for want of a better word. Let's bring this down to individual businesses and companies in terms of one, credibility, I guess, and maybe perhaps just give me a sense for the kinds of areas within the business that we may not, or that POPIA relates to, that we kind of may be aware of, but may also easily overlook in your experience?
Yeah, I mean, one of the areas that potentially can be easily overlooked is the relationship between ourselves and our service providers who are processing personal information on our behalf. What does that mean? It means if we have an incident and something goes wrong and our service provider is found to be at fault, suddenly we're going to scramble and understand that the POPIA Act says we should have done a risk assessment. Should we even be dealing with that service provider in the first place? Number one. Number two, we must have a contractual agreement with that service provider, which covers the requirements of the POPIA Act. And there's a common misunderstanding, which is, well, in that case, my service provider needs to be fully POPIA Act compliant. That's not true. The only requirement for the service provider is that they meet the demand of an operator as defined in the POPIA Act. It doesn't say the service provider needs to be fully compliant. Of course, an organization may go further and make that a registration requirement. And I've seen one of my JSE listed clients, organization employs 33,000 people, now has a 4-page document require an organization to explain the extent to which they're POPIA Act compliant prior to potential supplier registration. Third thing that's hidden behind that is, and we're just dealing with vendors who act as service providers processing information, so-called operator, or in Nigerian terms or in GDPR terms, so-called processor. POPIA Act and GDPR in equivalent terms says you need to have a mechanism to review the ongoing performance of that service provider, not in terms of an SLA, are they doing a good job, am I getting value for money, but does this organization represent a more or less serious risk to my business based on what's been happening in the last, let's say, 12 months. And there are lots of service providers out there who are going to lose business based on the poor reputation they have as being the source of an incident, in general terms called a data breach, in South African legislation it's called a security compromise, and pointing the finger and say, well, if my service provider caused the damage, isn't the answer. In fact, the POPIA Act holds the responsible party, what in European terms called the controller, directly accountable. In fact, in this country, South Africa, organizations who suffer a data breach are even more at risk of reputation damage, loss, and so on, than in the EU, where now the regulator is entitled to go after whichever party was responsible for any data breach. And that means that maybe the controller in Europe actually gets away with saying, well, you know, we did everything and we can pin it on our service provider, and the regulator agrees. And the primary party, the responsible party in South Africa, controller in Europe, actually gets away without any fine. That's not going to happen in South Africa. The regulator is going to want to hold somebody accountable. And go to the regulator's website, and you'll see several stories of views that they have expressed about unsatisfactory situations. I'm not going to mention any specific names. You can go to the regulator's website, go and look it up. And if they had had their enforcement powers, no doubt they would have done more than express their dissatisfaction.
Fantastic. So one of the things that you mentioned is a risk assessment or a readiness assessment, and I believe we have a poll that we've set up. So I'm going to ask our participants to just participate in a quick poll, if the support team can put the poll up. And essentially, the question that we're asking is, has your board or your organization received or completed a readiness report relating to privacy and data protection? So it would be great if you could answer that poll and let us know what your thinking is. Or what your point of view is, and we'll pick up the conversation very shortly once we've done that. Please feel free to participate in the poll right now. Peter, perhaps while people are in the poll, based on your experience and the work that you've done, on a scale of 1 to 10, how ready are businesses that you've been dealing with as a general kind of perspective for what is coming in compliance to legislation?
Yeah, that's tough, Kieron, because I've been surprised at how even some large businesses, and I'll tell you what I mean by large in a moment, seem to be relatively ill-prepared, whereas some small businesses have been working on this for some time. Why is that? I think at the large end, I'm talking about companies listed on the Johannesburg Stock Exchange, international businesses with subsidiaries in South Africa, large state-owned enterprises. Those large organizations, you will have said, well, surely that was, the whole issue around POPIA or whichever national legislation they're trying to comply with would have been done long ago. Not the case. I'm involved in multiple projects at the moment where an organization large by any measure, revenue, responsibilities, employees, customers, however you want to mention them, are still trying to catch up. And not only with POPIA, but with other national or international legislation, because they've had so much else to deal with. It's not through dint of ignorance or neglect. It's the fact that the executive and the board agenda has been so crowded for some time that actually the fact that there has been no enforcement powers in South Africa has given, in a sense, a breathing space, but that breathing space is closing very quickly. Now, at the other end of the scale, I've been interested in how many small organizations I've dealt with have taken the initiative far ahead of any threat of the regulator come knocking on the door. Why? Because they see the ability to, I think the poll results come back up. Let me just close my remarks. Their ability to compete by proving their readiness for data protection presents them with a competitive advantage. They're able to go proactively to their clients and say, trust us, we know what we're talking about. We've been down this journey. We're here to make sure that we are one less thing for you to have to worry about.
Yeah. Okay, well, thank you. I see the results kind of, I think, mirror and echo a little bit about what you were just saying in that.
No, Kieron, that's worse. Yes, 5%. And that would be, I would think, a source of serious concern. Of course, that may represent only a breakdown in communications, in that the business, the organization, has been doing a lot of work, but the message is not getting through to the board. That would be an optimistic interpretation. The pessimistic interpretation might be even those boards who have received the report may, in some cases, be being misled by management who are trying to cover their tracks. I'm not saying there's any dishonesty, but you know how information can break down in the communication.
So, given that sort of result, let's talk a little bit about, and again, we kind of started on the national level, brought it down to a company, but let's go a little bit narrower than that, and let's talk about it specifically from a board and a board's perspective and responsibilities of the board from the point of view of data protection and privacy and everything else, and perhaps a little bit around the implications of non-compliance and what those are.
Yeah, so if we look at a framework such as King 4, across SADC, we know it finds a lot of favor. There are countries outside of the SADC region that still subscribe to King 4 as a good governance framework. We look at the role and responsibilities of the board, and we find words like strategy. So now, what should the strategy be for privacy? Is this a minimum compliance strategy such that we're going to try and reduce the cost of implementing appropriate protections at a minimum level aligned with affordability? Or is this going to be a proactive strategy which says the nature of my business, the services I offer, this presents me with an opportunity to take a very positive message as the board and executive management to whichever group of stakeholders we're most interested. I'm currently in the throes of talking to an international non-governmental organization that's involved in looking after beneficiaries in the community. That organization has a tremendous role to play in helping the people that they're trying to help, their beneficiaries, understand why they can be trusted. Some of you on the call may remember that it's not very long since the World Food Programme received the Nobel Peace Prize. And I'm delighted to say that I worked with the World Food Programme in one of their African countries. And in that case, the project was all around information. What information could or should the national government and the World Food Programme together be processing on behalf of the beneficiaries? And the ability for the board and executive in those organizations to understand the implications that the strategy of what they're trying to achieve may be blocked by resistance from the beneficiaries, by the stakeholders, suddenly becomes a significant issue. Next, in terms of the direct accountability of the board for policies. So, all and responsibility of the board, approve policy at the highest level. Well, now the board and directors and the committees reporting to the board need to understand who can we trust in terms of giving us advice about which policies we need? What should those policies cover? And beyond that, go and look at not only in the POPIA Act, but in GDPR, there's a relevant section, but I'll mention the POPIA Act specifically. Go look at section 109 in the POPIA Act. It says failure to carry out adequate risk assessments or to maintain good policies, procedures will result in a bigger administrative fine. So now the board has to say, if we're here to manage risk, another aspect of the work of the board, to manage risk and make risk-based decisions, how much are we going to put at risk? And quite frankly, the fines that are being raised in South Africa are tiny compared to the international implications, where you see percentage of global turnover being at risk. The fines isn't a big deal. Anybody who's sitting on a board of a financial institution in South Africa that's had to face anti-money laundering accusations and cough up hundreds of millions of rands have been paid by South African financial institutions in fines for anti-money laundering. 10 million as the cap on the POPIA Act. Some people are willing to say that's minor. The big risk is reputation. If the board is there to secure the future of the business and ensure we have an ongoing concern, reputation management is the issue. Is my reputation going to be damaged? And then it comes down, Kieron, to reputation as an individual. And you and I were talking before the call about some of the international examples. And I have a couple of articles which I think we agreed we'd send out to the delegates afterwards, asking the question, do you want to be the ex-CEO? Do you want to be the resigned chair of the board? Because there are personal implications, whether or not in law you stand liable. Many boards are not willing to take unnecessary pressure defending an individual who clearly has proven themselves to be on the level of capabilities. A chief information security officer, he's going to take, or she's going to take the fall. Today, that's not enough. The board wants to hold somebody seriously accountable. That's likely to be the chief executive. And in some cases, it can go further than that. You mentioned specifically, did you? I think you might have mentioned Facebook, but let's say you did.
Yeah, I did, yes.
Yeah, you did. Go and have a look at the ignominy that Mark Zuckerberg and his fellow directors have had to suffer, because following those notorious interviews, Facebook agreed to have oversight on their data privacy activities in the business. I mean, that's serious. Doing such a bad job that the regulatory authorities say we must implement new board level roles in terms of data protection.
Great.
Commenting about background noise, hopefully not from my end.
No, I'm not sure where it's coming from. Yes, Jack, I have seen your question and we will get to it shortly. So thank you for the question. And if there are any questions that have come to mind while Peter and I have been chatting, then please do post them in the Q&A section of the webinar. Peter, perhaps, and maybe not a bad opportunity to take a question here. And the question is from Jack. It says, I always wonder what is happening with information preservation, both in the public and private sectors, but of concern is public information in the hands of individuals. Given the fourth industrial revolution challenges and opportunities, where do you think companies should begin to start appreciating preservation of information and also thinking about data mining for development requirements?
Yeah, so let's tackle the public sector first. I have several public sector clients who are much more diligent in the work that they do about information protection and preservation, because they have for some time been subject to the National Archives Act. And the National Archives Act, which applies to public state-owned three spheres of government institutions, laid down specific requirements around issues such as record retention. And that means that if the Archives Act is being appropriately, adequately paid attention to by the accounting authorities in those state-owned enterprises, the Director General reporting eventually to the Minister, nominally, South African three spheres of government should be in great shape in terms of retaining and acting as custodian to the types of records for which they're responsible. Should be. The reality is, Archives Act is not happening in many, if not most of those institutions. We know that because of the reviews that the Auditor General has carried out. So, as is often the case in the public sector in South Africa, intentions great, execution not so great. In the private sector, there's a stark awareness coming around now that the POPIA Act is forcing organizations to change some of their data custodianship activities. Number one, by recognizing you can't just lump everything together, put it in a digital box or put it in a paper box and keep it forever just in case. Why? Because there are rules now coming in with POPIA that say, once the purpose for which the information was first collected has been completed and that purpose is no longer valid, then the information must be deleted, erased, destroyed, whatever term you want to use. Now, that does not mean suddenly, oh, well, I've got to get rid of all my historic information. First of all, the POPIA Act's not retrospective. Secondly, this is an opportunity to wake up and realize that unless we invest in our data and keep it current, then data that's no longer valid may have little, if any, purpose. But also to recognize that we can mine historical data and look at statistical trends and exceptions and long-term patterns if we better curate the data we have. And the POPIA Act allows us to do that by keeping information, personal information. Of course, it can apply to non-personal information as well, for historical and statistical purposes, provided that it is, to use the term, pseudonymized, which is works impossible to say, that's the European Union term, and anonymized would be the term we typically use in South Africa. So the question around, can we get value out of data and data mining? Absolutely, and so few organizations are well set up to do that because they've had a history of not actually making much use of the historical data that's tend to be just dumped in case we need it, as opposed to saying we're going to curate it and leverage the pearls we have in terms of what's in the historical data. Think also that just because you've got new tools, you can go and mine lots of historical data and suddenly miraculously conjure up a whole lot of new customers. The approach in the European Union has been, if you don't look after the data, you can't use it. And there was a case, and I mentioned to you earlier, Kieron, that if you want to go to the tracker, which is out there, which tells you about all those fines in terms of GDPR, you'll find that one of the fines in the UK was for an organization that did a big dive into its historical customer records and tried to shake them awake by saying, hey, I haven't heard from you for a long time. They got fined for doing that. Regulators said you can't go back and treat people who you no longer have a business relationship as if they're your customer. You treat them as if they're not your customer. And there are rules then about how you do that.
So you've touched on a number of different areas, and I think the polls certainly indicated where things are at in terms of our audience today. So if I were a board member sitting on a board, either in a non-executive or an independent capacity, what would the sort of questions be that I would need to be asking of the CEO or of my audit and risk committee that would get the process going and getting the management and executive directors to start thinking about it?
Kieron, this is a bit like one of those cooking shows where you ask, and how does the cake look when it's baked? And I tell you, I've got one I put in the oven 20 minutes ago and it's ready to be served up. Yeah. What do I mean? I mean, I've got a list of the sorts of questions, and with your no doubt immediate agreement, I'm going to share the list. Just let me know you can see that.
I can see it, yes.
Yep. So here's a suggestion of some of the, and these are related to privacy, not to a particular national set of legislation. So all of those people are on the webinar today. This should be immediately applicable, not POPIA specific, not GDPR specific. So it's questions around privacy legislation. Now, it's not generic any legislation, it's related to privacy. So in some countries, they're more advanced than we are here in South Africa. They've had enforceable privacy legislation for some time. In South Africa, we know that the legislation is there, but the enforcement from the regulator is only coming in July this year, even though other stakeholders, such as auditors, investors, and others may want to have a better explanation than waiting for the regulator to come knocking on the door. So whether you're sitting on the board or a committee of the board, or you're in executive management anticipating questions coming from the board, or anticipating that your life may be made difficult by failing to demonstrate readiness, these are some of the questions that we need to think about. So, board perspective, let's take it from that direction. Has the organization appointed somebody to be accountable, whether they're called the information or data protection officer, depends on the nature of the legislation. But to say, oh, well, the legislation says that the CEO or the head of the business designated head is automatically there, so we don't have to worry. You absolutely have to worry. At least in South Africa, you have to nominate that individual, and very soon, from the 1st of May, is the latest guidance from the regulator, that individual has to be registered with the regulator. Next, you've got to make sure that people are given adequate notice and notification requirement. Now, we all know that there are privacy notices out there every time we visit a website. The only trouble is that many of those are not aligned to the appropriate legislation. So whether you're in South Africa or you're subject to Nigerian data protection regulation, or wherever you are across Africa in terms of doing business, think about the type of notification you're going to put into the hands of people who are internally entitled to understand how you're going to deal with their information. Staff or employees have a very different set of requirements to your external stakeholders. So immediately you suddenly realize, hey, we need more than one type of privacy notice. So this is a fairly pointed area you can ask of the executives or ask of the committees reporting to the board. Where are we on some of these key deliverables?
So Peter, just in the interests of time and
I'm not going to read all 25. Don't worry.
I appreciate that, but also just to let our participants know that as a little value add to today, we'll be sharing that list with them. So if they didn't get all of those questions, I think perhaps, and just having had a look through that list, there's obviously some areas that are relatively low-hanging fruit and good places to start, and some that are a lot more complex. So I guess two aspects to my question. What are some of those low-hanging fruit areas on the one hand, and on the other hand, where it gets a little bit more in-depth, can an organization tackle this on their own, or is it something that you would generally recommend that they seek professional help, if I can put it that way, or to do it? So those two questions from my side.
Well, actually, there's three ways to go. Number one, you do it yourself and trust that you've got the answer right. A very interesting approach, which I've been involved in several times now, is the organization believes they've done the right thing, but now they ask for an external party to come and evaluate whether or not they've got the right answer. So you go for the independent review of the work you've done yourself. That could prove to be an insightful experience if you have a team internally, whether they're from governance, risk, compliance, or legal, who are maybe not experts in the field, but they say, hey, we've implemented compliance with the legislation, how can this be different? Well, then get an external view just to have a double check. The other case is where, even in some large organizations, the in-house skills, knowledge, and experience are not focused on data privacy. So a very competent legal team, a competent risk management team, but unfamiliar with the area of data privacy protection, privacy legislation, in which case seeking external advice is absolutely the way to go. Not just because I'm in that business, but because many of the people who are out there who are looking for advice have gone to the market using tenders and so on to go and seek the sort of advice that they realize they don't have internally. Yeah. Now, how you do it is up to you as an organization. And in terms of the low-hanging fruit, there are some things on that list which are sort of no-brainers. And the more you show your face to the public, the more you'd say, but that's obvious, isn't it? Get a privacy notice on the website that meets the requirements of GDPR or POPIA or whatever your local legislation is. In South Africa, we have the oddity of having something called Promotion of Access to Information Act, which requires we publish a manual. But in other countries where freedom of information is the term that's used, have a look at what the requirements are around freedom of information. Number one, wherever you are, train your staff. Train them in what? We'll train them in some basics. Train them in awareness, train them in good habits, and train them in being sensitive to the way they manage personal information. A really insightful way to do that is unannounced, have a clean desk review, not just go and see, hey, has Mary or John or Glamini or whoever left too many papers over their desk over lunchtime, but look at their overall conduct in terms of how they look after information. And use that as a springboard to say, guys, we've clearly got room for improvement. So, staff training, put in place the right policies, make sure you update your contracts. Absolutely go into cybersecurity, because that's already been a hot topic for board discussion. Make sure that I'm now aligning my generic cybersecurity to look at what's required in terms of POPIA or whichever legislation. Great. So what we normally do, and I can't remember if we had something along this line of discussion before, Kieron, is we look at a typical 20-question health check, and how do I shape up on that? And don't get the board to take that. Get the executives to report to the board on how did they score on that type of high-level assessment. And given that we've had the poll which says only 5% could say yes, even though there was a lot in progress, 60-odd% are saying no, not even there. So lots of room for improvement. Communication.
Okay. Great. Okay, so we have a question. Thanks, Peter. We can perhaps touch on that before we close again. Question from Richard. We have legislation that is supposedly there to protect and prevent the use of personal information, such as the NCA. Cold calling was supposed to have been halted at the threat of ramifications, yet weekly one receives calls from insurance companies, banks, and cell phone providers who clearly have our information. We were informed that all of this would stop, as there were going to be severe penalties and fines. So I wonder if POPIA might end up being the same, perhaps.
Well, Richard, that's an interesting question. And the simple answer is, it's not going to stop. Not going to stop anytime soon. There will be a reduction, no doubt, once the regulator exercises the right to take action against offenders. But sadly, because there is so much of our personal information already in the public domain or available from public sources, number one, we're not going to be able to easily shut off the tap of personal information being in the hands of people who are not going to follow the rules. Number two, if somebody doesn't follow the rules, it's going to be up to us as individuals to exercise our right to object, to make sure that the regulator takes appropriate action. Now, if you look at the case of Cambridge Analytica in the UK and other examples of gross abuse, those types of gross abuse of our personal information not only make the headlines, it ends up with pointed questions being asked of people who very soon after lose their job. And the more those implications of the public holding us and the bad actors account, we need to be more responsible in the way we treat our personal information and, in a sense, start to care more. And those people who have an influence, including the press and other stakeholders, need to make the pressure felt. But it's not going to stop. There are still grounds on which you can be approached and a mechanism through which you can be approached under the POPIA Act, even if it's only once. So those people who want to send you that, and what I'm finding now irritating is the spam WhatsApps, the growing number of automated calls to my cell phone. Those things are hugely irritating. Sadly, not going to stop anytime soon. It'll slow down, The regulator, if they take action, will help to do that. But got a long way to go.
Mm.
Look, I mean, if you, sorry, go ahead.
Yeah, go for it.
No, I'm just going to say that, sorry, we've got a lag on the line there.
Yes.
Yeah, I mentioned earlier today, Kieron, that, if you go to enforcementtracker.com, that's the name of the website. We can happily put it in the window if you want to have it there. But Enforcement Tracker tells us the stories about the action taken by a range of European authorities using the GDPR as the legislative base on which they will pursue people who are doing wrong. There was a case came out of the UK recently. UK regulator, just to give you an idea, has over 750 staff, and our local regulator currently has less than 50 staff. Yeah, enforcementtracker.com. So we have a scenario in the UK where the regulator has real key exercises that, and an organization who was sending out unsolicited electronic communication, to use terminology in the POPIA Act, was hit with a really big fine. We've got to see some really big fines. And that's only going to start after 1st of July in South Africa. It's happening in other countries already.
Right. And I suppose from a personal perspective now, we're not always aware the extent to which we give our personal information away. We sign things, or we agree to things, or we complete a form somewhere here without necessarily reading the fine print. And that's obviously something that we all need to be conscious and vigilant of as well. Yeah,
look, I mean, there are some cases where information is forced into the public domain. Think deeds office, think CIPC registration, think company website and think LinkedIn. All of us are my buddy who I walk with on a regular basis said to me the other day, hey, that new app I've got is great. It tells you everybody's email who's registered on LinkedIn. No wonder we're getting. I phoned somebody the other day that said, where did you get my number? I said, I used an app. So it's out there. The question is this a legitimate basis on which you're doing business? And the more all of us start taking action, the better it will be. Sadly, at the moment, the regulator is understaffed, underfunded. The regulator herself, Advocate Plakula, has said that on numerous occasions. I mean, what can you do with £1 million? You can't even hire a civil servant these days. Certainly if it comes down to giving them an office to sit in and whatever. And last I checked, Advocate Plakula only had a £40 million budget. So she's going nowhere in terms of ability to do other than tackle the really big issues until we recognize, as she herself has said, as other national regulators have recognized, data privacy is now an absolute must if we're to be trusted as a trading nation and boost the extent to which we're recognized and respected by international trading partners.
Great, fantastic. Folks, we've answered 2 questions. I'm not seeing any open questions in either the chat or the Q&A section. I don't know if there are any live questions that any of our participants would like to ask at this particular point in time. We have about 8 minutes or so left of our scheduled time. But if there are any questions, please feel very free to put them out there for Peter to answer.
Perhaps Kieron, maybe there's a couple of questions are coming in. If I can just say that I've got a couple of articles which I'm going to suggest you send out afterwards, not because they're about South Africa, but because they are not about South Africa. You've got to understand that we are behind the curve. So when we start reading articles which have headlines such as individual criminal liability for failure to disclose data breach establishes a new level of risk for companies and executives, we have to say that's an eye-catching headline. The risk to the executive as an individual. Another article, want to keep your job, Mr. CEO, slightly sexist, but anyway, you better take data security seriously. And in that article, it talks about Equifax and how the CEO was called into the US Senate about Target, a major retailer whose CEO left under a cloud after a major data incident. So we'll send those articles in the 25-point checklist, and I think that'll give lots of ammunition, not only for further consideration, but for some pretty heated discussions, I'm sure, if not at the board, in the committees, or at least with the EXCO, to find out whether or not there's some lingering risks that haven't been fully appreciated.
Right. So I'm not seeing any more questions coming through. I think perhaps maybe just one last question from my side. So having heard what I've heard today, and perhaps I've recognized that there's a few areas that we're lagging up. We have one. The information officer role seems to be quite critical. Would you suggest that this be an in-house or external person?
Now, that's a very interesting question, because the regulator has been hinting recently that the regulator wants to see the information officer remaining in-house so they have a more direct leg of accountability. In fact, the information regulator has even hinted that despite the legislation allows an organization to nominate an information officer in place of the CEO, the regulator has hinted that they don't want that to happen. They want to have a serious level of executive commitment, because that individual may be the one who's going to go to jail. The POPIA Act says if you have an infringement, the regulator has a right to raise a fine of up to 10 million rands per incident, and that failure to pay the fine may result in somebody going to jail. The last thing the regulator wants is to have some outsourced person going to jail instead of somebody in the organization. Likewise, the regulator doesn't want to see a junior person in the organization taking the fall for the bosses who just didn't care. Now, the truth is, we don't know exactly what's going to happen yet about the ability to appoint an outside person, because the final guidelines on registration for your information officer have not yet been published. We do have a statement from the regulator, even though it's not easy to find on their website, that registrations for the information officer will start on the 1st of May, despite the fact that July last year, when the draft guidelines were published, it was suggested that we all need to have our information officers registered by the 31st of March. Right now, the regulator hasn't even told us how to do that.
Great. So we've got some very nice comments. Thank you, Richard, Vinod, for yours. Roger, thank you for yours too. And Jack, thank you for your participation as well. And yes, we will certainly circulate some of the information as well as contact details. Peter, thank you very much for your time this morning. Every time I speak to you, I learn more as well. So folks, please do feel free to get into contact with ourselves and or Peter, and we'll most definitely be able to assist with areas relating to data protection. Peter, perhaps closing comment from your side?
I always like to remind people that South Africa is far behind, but we've got an opportunity to catch up, and that growth rates in countries that have adopted data privacy have tended to outstrip South Africa over the last 30 years. This is not just red tape and overhead. It can provide us with an ability to improve our international competitiveness. If we get this right as a country, then it's really going to be good news for all of us. So we need to start off by getting it right at the company level to get the country on track. Thanks, Kieron.
Peter,
Appreciate
thank you.
the time you've given me.
Have a great day, and yeah, look forward to chatting some more about the subject. So thank you.
Thanks. Thanks to everybody.
Thank you, everybody, for attending.
Cheers.
Cheers.